and just say, Janet Booker Davis, Chair, good to see you.
Am I on and being heard? Yes? Okay. Thank you, Chairman Bonner. We have one item on the licensing committee agenda. We're to consider CPE that was delivered by the Association of Colleges and University Auditors, ACUA, during a time when they had a lapse in their registry, being registered as a sponsor. So in terms of background, the ACUA has been a NASBA-approved provider for 33 years. And during the period of July 1st, 2023 through June 14, 2024, I think is when they had the lapse of time in their registry. And we had 2 to 3 licensees in Tennessee that were impacted by this. The ACUA acknowledged the error. There was a change in their third-party administrator for some of the administration of their sponsorship, and so that's how this occurred. The board rules require CPE to be earned by NASBA registered sponsors unless the organization is exempt, which ACUA is not exempt, but an organization, a professional accounting organization, universities and colleges, those are some of the type of organizations that are exempt. And you all have this in your pre-meeting material. The rule that we could consider approving or disapproving the credit is Rule 0020-05-.04, paren 10, close parentheses. So what we were called to do is to have a discussion amongst the committee to see if we want to approve or disapprove the credit for the folks who are wanting to claim this CPE. So I'll open it up for discussion to the committee and any other board members who want to comment. Is there any discussion?
I'll add to a couple of comments. I don't think it's appropriate for us to penalize the licensees who've obtained credit under this program. In lieu of the information we've received and the longstanding position of the ACUA, 33 years with NASBA, I would support a proposal that we somehow get this retroactively approved.
That was my thinking as well. And I guess one other comment I could make is that the ACUA has been reinstated as a registered sponsor effective June 14th of this year.
I would agree with each of your comments.
Okay. Do we want to make a motion to present to the board tomorrow to approve this then?
I'll make a motion to approve the credit retroactively as proposed by the chair. Thank you.
Okay. Second?
Second.
Okay. Then that's the motion we'll take to the, oh, do we need a roll call or any? Yeah, all the committee members, yeah, I guess. Okay. Okay, all in favor?
Aye.
Aye. Okay. Any opposed? Okay, motion carries. Look like we're all in agreement, so we'll present this to the board tomorrow, and that's all we had for my committee. And since I am here, I'll just say thank you all. It's been a pleasure to be serving all these past 9 years.
Thank you.
She got a lovely plaque.
And I got a lovely plaque that's blue that matches. It's my favorite color.
All right.
Thank
Thank you, Chairman.
No.
Appreciate that. I will say that we are operating, as most everybody knows, but I know a couple people don't, or if you don't remember, we're operating with the new technology, which means only 4 people at a time can be lit. So if you do punch, and then once you speak, if you'll unpunch, that would be great for anybody else who wants to pop in. And I don't think it'll be a big deal today, but tomorrow it may be a big deal. So just remember that. Chairman Griesbeck, laws and rules, please, sir.
Thank you, Mr. Chairman. We have one item on the agenda also today. We thought we had done this last time, and we did, but we're going to come back and, I guess, have a redo, but that's okay. So you'll remember that our May meeting, the board approved amendments to Chapter 0020-06 related to the peer review program. Further, we authorized staff to move forward with the rulemaking hearing. And you received an email here recently from Wendy regarding suggested changes from the department's legal counsel in the review process. And she also included, I believe, 2 versions of the changes. One that we approved amendments from our last meeting, and then also a red line version with the suggested changes now. And I'd like to ask Wendy to maybe just run through those proposed changes. They're not real complicated, but mostly some grammatical, but some of substance a little bit. So if you'll do that, Wendy, for us, it'd be great.
Oh, I got it. Thank you, Mr. Chairman. Of the peer review changes, some of them, as John mentioned, were grammatical. In the definitions section, it was determined that we just needed to alphabetize those definitions, so that was changed. And then in a few areas throughout the rules, we had previously referred to Tennessee Code annotated, spelled out to some degree, and that is being replaced with TCA rather than Tennessee Code annotated. So those are the basic changes that don't have much substance to them. But the last one is in paragraph, or section 7, paragraph 3. We did reword that section throughout to make it clear what was needed to be provided in 30 days. So we are requesting that CPA firms, once they complete their peer review or during the process of their peer review, that they submit certain documents and objective information. So the challenge with this section is that some of the items they have to submit would be in letter form, and others might simply just be a date. And so it was a little difficult with that language just to make it clear what it was that they needed to submit. So General Counsel suggested some changes to that section, and to be safe, we wanted to bring it back to you for consideration. Am I fairly saying this, Laura?
Yeah. So honestly, if not for the rewrite in paragraph 3, we probably would have considered the other changes not substantial enough to need, another board approval of the rules, but we did pretty substantially rewrite paragraph 3. I will say, I don't think that we weren't rewriting it to change the requirements. It's just once we had general counsel who had not been plugged into this, once we had people reviewing this that weren't so plugged into the issue, we found that it wasn't very clear. And so we kind of tried to rewrite the language to make it clearer. So if you want to review that paragraph 3 in section .07, and then we can hopefully
What
Wendy and I
page is
can
that
answer your
on? There's so
questions.
much red line here. What page is that on?
7.
Page 7? Okay.
Wendy, correct me if I'm wrong, but it looked like if you go down each item, A through F, they each address the same issue as the old one, with just the wording is changed to further, better indicate maybe the 30-day.
Correct. There was really
Period.
no change in the meaning.
Right.
It was just some wording changes to try to make it
Right.
more clear what we were asking for.
Okay.
I did also share this with Kara and TSCPA, and they did not have any further comments.
Will this be subject to another review as we had before, I guess?
Sort of. So right now, where the rules are is considered like the department's internal review process. So after I got the approval from you guys at the last board meeting, I had to write a bunch of accompanying documents, which are things that you've probably seen at a rulemaking hearing before. It went through me, it went through Wendy, and then it started to go, through my supervisor, and then all the way up through the general counsel. And we're technically still in the middle of that process. It's just that if we change anything substantially enough, we like to come back to the board to get to, just to make sure that we haven't unintentionally changed your intent without your approval. And then after that happens, we'll set the rulemaking hearing. And so that is when, members of the public can come and comment on it. And that is when you guys will review and hopefully approve all the documents that go with a rulemaking hearing. So you will see it again, but that will be sort of a more finalized version, if that makes sense.
Does this necessarily mean that we'll have slowed down the rulemaking process 3 months?
This right here? Not really. In fairness, we had, Neil took another job, so then I picked this up sort of midstream from him. And then, honestly, it was only, 2 weeks ago, I think, that you and me and Michael sort of finalized our review of the rules. And at that point, he said, I think you need board approval before we move on to the next step. So, no, rules are notoriously slow-moving.
Has everyone had an opportunity to look through the changes and Wendy's comments? Are there any questions for Wendy or Laura related to this? If not, is there a motion to approve these amendments? Can I make a motion to approve the amendments? Okay, I would make a motion then to approve the amendments as presented.
Second.
Any discussion?
Is the committee all in person? Oh, then we have to do.
Do I need a roll call? Okay, Karen?
John Griesbeck,
Aye.
Sam Bennett,
Aye.
Janet Booker Davis,
Aye.
Pam Church,
Aye.
David Crenshaw.
Aye.
So the motion carries and will be recommended to the board at our meeting tomorrow.
All right, thank you, Mr. Chairman. Next, we have enforcement. Chairman Monroe?
Thanks, Mr. Chairman. Well, we've got a fairly nice plate of work before us with respect to some 21 or thereabout cases that we'll be going through today. The way for those that are listening in from the public, our first set of cases, numbers 1 through 11, are on what we call the consent agenda, which means that there is no formal proposed discipline with respect to those. And so we'll deal with that group of cases first, and then we'll proceed to the cases where there would be proposed discipline. With respect to the consent agenda, the first 4 cases essentially were based on complaints that were filed and investigated, some relating to due care, and one relating to failure to return client records. And as it turned out, based upon the investigation results, the recommendation from legal and staff is to close those complaints based on a lack of evidence to establish a violation for those 4 items. The 5th item essentially is a billing dispute, and under longstanding practice, this board does not participate in solving billing disputes. So that case is also recommended for closure with respect to that item. The next items, actually there are 3, items 6, 7, and 8, that deal with basically inappropriate or potentially inappropriate use of accounting, either in the firm name or using it without a firm permit, or using it in accounting in terms of advertising in a Tennessee location. And so upon investigation by staff, it was determined that there was not enough evidence to establish a violation, but generally speaking, we are submitting or recommending letters of instruction to the respondents in those cases. And finally, the last three cases in the consent agenda item all follow up essentially from the same PCAOB regulatory matter, whereby the PCAOB basically dealt with discipline relative to a particular case. This then resulted in three kind of sub-cases for us. And at this point, we are in the stage of waiting for the PCAOB to provide us with enough information to determine whether and to what degree we need to explore additional disciplinary proceedings against the respondents or the folks that were named in these PCAOB actions. We do not yet have that information. I think my understanding is that there's been a lot of back and forth in terms of to what extent the PCAOB will be sharing information with our board on these matters so that we can proceed. So the recommendation here is to place these three last items in the consent agenda in litigation monitoring status until we can determine what we have on our hands from the PCAOB. Let me stop there and see if there are any questions from committee members or other board members here before we proceed to deal with the consent agenda items.
Mr. Chairman?
Yes.
Larry has a comment online.
Okay.
On case number 4, respondent says it was legal work. I was always under the impression that CPAs who are also attorneys had to choose one or the other and not practice both. Did that change?
For number 4, this respondent was solely engaged in legal work for this matter, but they do have a CPA license, so they felt compelled to respond to the complaint on their letterhead, is what Duke and I discussed.
Yes, that's correct. She is a practicing attorney, and this was a legal engagement, not a CPA engagement. But because respondent maintains a CPA license, they felt compelled to respond to the complaint filed against them.
Bless you. Thank you. We'll give Larry a chance if he has any follow-up questions to follow up online here for a moment.
He's responding to the affirmative. He's happy with the answer.
Okay, thank you. So that completes the summary of the 11 items or cases in the consent agenda. I would make a motion that the committee recommends to the board the recommendations that are proposed for each of the cases in items 1 through 11 on the consent agenda.
Mr. Chairman, I would second the motion.
Okay, thank you. Any other questions or comments on the consent agenda items 1 through 11? If not, Karen, would you please call the roll?
Kevin Monroe,
Aye.
David Crenshaw,
Aye.
Larry Elmore,
Larry votes aye.
Greg Gilbert,
Aye.
Rob Vance.
Aye.
Thank you. That motion passes. We'll now proceed to the section that involves proposed discipline. And we have a number of cases here with respect to those items. Let me just get to the right page. Here we go. The first case is item 12. This relates to the use of accounting. And in this particular case, there were complainant allegations against the respondent with respect to fraud. Among other things, the respondent did reply through counsel. The respondent is not a Tennessee licensed CPA, and so those allegations are not under the jurisdiction of the board. However, the issue here is that in the response, the respondent's signature block included the term accounting pertaining to the respondent's firm name. The respondent did confirm that they do not have a CPA license. And so the recommendation in this particular case is to authorize a formal hearing with the authority to settle via a consent order requiring respondent to change the name of their business within 60 days of signing the consent order. Further, in the event that the respondent does not change their name in the aforementioned timeframe, authorize assessing a $500 civil penalty. What I would propose that we do for these cases, if we have questions as we go along, please feel free to ask them of me or of Wendy or of counsel. And then what I would recommend is that unless there are any that people want to vote on separately, we'll vote on the recommendations for these cases also in a block, similar to the way that we handle the consent items. So with that, I'll proceed to the next item, item number 13. This relates to unlicensed activities. The next several cases involve complaints that are arising from work that was performed and submitted to the Contractors Board here in Tennessee. And in many cases, that requires the contractor to obtain some level of attest opinion or report on financial statements that are then submitted to the Contractors Board. What then happens is the Contractors Board, after the fact, will run a check to see if the CPA firm that was doing that attest work was properly licensed and whether or not they had a firm permit to do attest work. And so these next several cases are situations where, as it turned out after the fact, it was discovered that the CPA firm allegedly did not either have a firm permit or was not properly enrolled in peer review, or both with respect to that. And so item number 13 is a case in hand. In this particular case, there was a situation where they had neither peer review they were issuing two reports without being a registered firm, and they did not have peer review. So I'll read the recommendation. That is authorizing a formal hearing with the authority to settle via consent order, assessing a $7,000 civil penalty based on $3,500 per review report issued without being registered as a firm or in accordance with peer review. And further, council recommends requiring respondent to complete the 3-part NASBA Ethics CPE course. So that's item 13. With respect to case 14, this is also a Board for Licensing Contractors issue. In this particular case, the factors that were related to this indicate that the respondent admitted to the alleged violation within their response. They did indicate that they don't normally, in a normal course of business, conduct these kinds of attest engagements and issue engagement reports. They also indicated that the firm recently moved to Tennessee and was not completely familiar with Tennessee statutes and rules. They now have been advised of those statutes and rules. There seems to be only one attest report in question that was issued by the respondent that would be in violation. So in this particular case, the recommendation is authorize a formal hearing with the authority to settle via a consent order assessing a $2,000 civil penalty based on $1,000 for failure to comply with peer review requirements and $1,000 for providing attest services without a firm permit. So that's item 14.
Mr. Chairman, can I just make sure there's something clear about this one?
Yes.
This firm and the owner of the firm are not CPAs, so they don't have the option of becoming licensed or complying with peer review because they don't meet those particular requirements, which that one's this is different about this one compared to the other ones.
Thank you for that clarification, Wendy. If there are no further comments on this one, we'll go ahead and proceed to case 15. Case 15 is also involving a case where we have an attest work. The complaint was opened internally based on an audit report appears to have been issued in December 19th of 2023 by the respondent. A firm permit is required to issue such an audit report in Tennessee. Records indicate that the respondent's firm permit expired on December 31st, 2022. In the response, the respondent expressed surprise to learn that their firm permit had indeed expired, and they indicated that they had inadvertently overlooked renewing the firm permit. They admitted to conducting the audit and issuing the correspondent report. They also indicated that there were no plans to continue providing attest services in the future. This is a sole proprietor firm that does not have any employees. With respect to this, the recommendation for discipline is to authorize a formal hearing with the authority to settle via a consent order, assessing a $1,000 civil penalty. Council further recommends including in the consent order the reminder that if the respondent decides to perform a test work in the future, they must renew the required firm permit. So that's item 15. The next item is item 16, and that relates again to a Board of Contractors situation where an independent auditor's report was issued by the respondent. There was no record found of a valid firm permit or peer review enrollment associated with the respondent. The recommendation for this case is to authorize a formal hearing with the authority to settle via consent order, assessing a $1,750 civil penalty. The civil penalty is based on $750 for failure to have a firm permit and $1,000 for failure to comply with peer review requirements. The last part of the recommendation is to require a respondent to complete the 2-hour board-approved state-specific ethics course. My question when I initially reviewed this was, well, doesn't every licensee have to take this course? And the answer is, if you're a Tennessee licensee, you do. However, in follow-up with Wendy, the licensee here is actually licensed in, I believe, another state jurisdiction and would not normally, under the home rule law, have to take the Tennessee state-specific ethics course. Management or staff and council felt that because of this type of violation and its uniqueness to our Tennessee regs, that this was an appropriate recommendation to add in addition to the recommended civil penalty on this one. We'll proceed to item number 17. This is another licensing contractors, board for licensing contractors case whereby a respondent issued a review report in February of 2024. The board for licensing contractors asked our board to assist with license verification. It was determined that the respondent did not have a record of a firm permit or peer review enrollment for the firm. However, they did have a firm permit under a different entity name. In this particular case, the respondent expressed remorse throughout the complaint process. They have now re-enrolled in peer review with a due date of August 31, 2025, and they have no history of prior discipline. So the recommendation here is to authorize a formal hearing with the authority to settle via consent order assessing a $1,000 civil penalty. The next item is also a board for licensing contractors. This is item 18, whereby a review report was issued by the respondent, and it determined, and our board determined that the work was performed without a valid firm permit or compliance with peer review requirements. The respondent was apologetic about the misunderstanding and the improper actions. In this particular case, the recommendation here is to authorize a formal hearing with the authority to settle via consent order assessing a $1,750 penalty. The civil penalty is based on $750 for failure to have a firm permit and $1,000 for failure to comply with peer review requirements. And that would be the standard discipline under our disciplinary matrix for this violation. And finally, not finally, we have a couple more. In 19, we have another Board of Licensing Contractors case where a review report was prepared by the respondent, and we determined that a valid firm permit or peer review enrollment was not indicated for the respondent. In this particular case, the respondent is originally licensed in Iowa, and after initial attempts to locate the respondent, there was some progress made. In this particular case, the respondent signed the report with an Iowa license designation on letterhead of an unlicensed Tennessee firm. The respondent does not hold a Tennessee CPA license. In this particular case, the recommendation is to authorize a formal hearing with the authority to settle via consent order assessing a $1,750 civil penalty. And also further, counsel recommends referring this matter to the Iowa Accountancy Board. And on this one, I would turn it over to Wendy just for a little elaboration. There were efforts to reach out to the Iowa Accountancy Board to sound it out about its propensity for going ahead and prosecuting this case under its jurisdiction. And Wendy, I'll just let you follow up with elaboration on that.
I may let Duke do that since
Okay.
he's the one that reached out in that particular case. But this is an example of really a mobility type issue to some degree. We have a licensee in Iowa who has signed an attest report with their own name, but on the letterhead of a firm that is here in Tennessee. So you have a lot going on here. The firm that contracted with this individual is not a CPA-owned entity, so they cannot have a firm permit and should not have been issuing the attest work. So Duke, do you want to elaborate on that at all?
Sure. So just for even more clarification, actually,
Sure.
this item 19 is related to item 14. Okay, so that was the firm which this report was completed for. So it was completed on firm letterhead, but signed by the individual in 19. We didn't have any contact information for 19, so when I contacted staff at the Iowa board just to get some contact information, they provided what I would say little information they had. I mean, it's their business what kind of information they had, but it wasn't much. And then I said, hey, would you like me to refer this all to you? And they said, no, not right now. That was my opportunity. I felt an opportunity to refer it then, but maybe more of an official one coming from the board might have some more teeth than just me offering it to them. So,
Thank you for those clarifications. And it was for that reason that I think staff indicated that perhaps it was appropriate for the Tennessee board to go ahead and act on this disciplinary case. We will still refer it, if the board determines that this penalty should be in place, we will still refer it to the Iowa Accountancy Board so that they will have a record of it, and then they may proceed as they see fit. The next item is case number 20. In this particular case, there's also a lot going on with respect to this. And so what we have is a complainant that was alleging essentially fraudulent activity on the part of the respondent for a prolonged period of time. And in this particular case, there were allegations of unauthorized withdrawals. There's a fair amount of information here in the case facts supporting that. And at the end of the day, the preliminary recommendation here is to discuss. And as I was doing the pre-review in preparation for the committee work, the question that I had to staff and council was, in this particular case, we had done some investigatory work, but at that time, the case had not either been referred to criminal on a criminal basis, nor had the complainant initiated any kind of a civil response or case at that time. Normally, our board is not, a finder of fact of original jurisdiction when it comes to criminal or even civil matters. And so the concern I had was, is it premature for the board to be weighing in on discipline for this particular case when the complainant had not filed either, any kind of a criminal complaint or at the time initially a civil complaint? Because we're not really well equipped to adjudicate those kinds of matters. And so in discussion, although it looks like there are definitely some issues of concern, if true, I think the view that I had was we should place this in litigation monitoring in the absence of further comment. And I'll turn it over to Wendy and investigative staff or counsel to kind of elaborate on the latest that we have regarding where this stands on the part of the complainant.
I'll refer to you all.
I'll just briefly discuss what Duke and I spoke about. So Duke recently just reached back out to the complainant after we spoke with you, and
Chris, can you hear me?
yours sounds like it's
Come sit here.
just if they're focused.
I can hear you guys now.
Okay. Thank you. I'll just start over. Duke and I, we started looking back into it after we touched base originally on the legal report, and Duke reached back out to the complainant who had expressed that in the coming weeks they're going to be filing a civil suit, and they're trying to get that together with their attorney. They do have representation at this time, correct, Duke? Yeah, so they're working on that. And then as for the criminal cases, they have referred it to 2 different legal agencies, and that's still, there's not been much traction on that, so we haven't heard too much about that. So what we had discussed is just putting it into litigation monitoring for at least 1 session, and then touching base again on October when we have more information, hopefully. I don't know, Duke, if you have anything different to add.
No, I mean, that's pretty much my conversation with the respondent when I spoke with her last. When it comes to law enforcement issue, maybe provide a little bit more clarification, is the dollar amount of what I suspect may be theft. You could be running into a threshold issue in separate jurisdictions. It may not be a high enough dollar amount, well, it's a lot to me, but for them it's just in terms of resources and how much the dollar loss could be in terms of whether they'll provide staff to that to look into it from a law enforcement perspective. So you're kind of in that void of what do you do. Also, there is, complainants here, respondent, we believe, is living elsewhere out of state and have really good reason to believe that they're there. So there's also a jurisdictional issue in terms of, what we believe the activity to have occurred. Where does the jurisdiction lie in terms of, investigating and prosecuting that? I believe it's where the respondent lives, but, I think the respondent's been getting some pushback from both law enforcement agencies over who has responsibility for that. So that's kind of where the criminal investigation part is kind of lagging a little bit behind, because it's just, I think a dollar amount for the threshold may not be enough for them to put resources to it right now.
Thank you for that elaboration. I think from my perspective, if we were to try to proceed and impose discipline, in essence, we would be the original trier of fact. And that could also come at the cost of either the legal, criminal proceedings, if there are any, or the civil proceedings. And that's something that we traditionally have tried to avoid. And so that's why I was comfortable in follow-up discussion with the recommendation here to place in litigation monitoring, at least for 1 board meeting cycle, and then we'll just continue to monitor as it proceeds on this one. Any other questions or comments on this one?
I would just say, based on my experience with these types of things, this is going to take a long time. I mean, and I agree with Duke, criminals probably not going to pick it up. It's not, it's a low dollar amount. Plus, my experience also is they want it wrapped up with a bow. They don't have the FBI behind them. And so that will probably not happen, in my opinion. And on the civil part, we'd be months down the road before we see anything on this. And he'll have to respond to that, or he'll get a default judgment, and then we'll know. So.
And the respondent advised they planned on doing it within a couple weeks in terms of a civil suit. So there are some things they need to get, as you can imagine, unwinding all this has taken quite a bit. And then some of the activity that complainant believed the respondent was responsible for completing wasn't done, so that had to be completed before they felt they could follow the appropriate suits.
Thank you. We have one last item that's been added to the agenda, and it is a representation. It should be on your iPads, and I think Wendy had distributed, it's a two-page item here to you here prior to the meeting. And this is from a situation that had previously been placed in litigation monitoring, and there have been further developments with respect to that. And ultimately, the case revolved around whether or not the respondent violated their duty as a power of attorney and whether they misused funds that were intended for the care of a relative of the respondent who was in declining physical and cognitive health. So this resulted in litigation, and so subsequently, on January 8th of 2024, a default judgment was entered against the respondent. And then also on March 19th of 2024, the court ordered damages against the respondent in the amount of $125,507.16. And the court, in doing so, made several determinations. And with respect to those determinations and discipline from our perspective, the issue is to determine now discipline that would be appropriate to the respondent from a Tennessee Board of Accountancy perspective. In this particular case, the recommendation is now to authorize a formal hearing with the authority to settle via a consent order seeking voluntary surrender of the respondent's license. And so that's what we have in terms of the representation matter for this particular case once the court disposition has now been made clear. Any comments or questions with respect to that representation item? Okay, we'll just kind of back out. Are there any comments or questions on any of the items under the proposed discipline category?
On item number 13, in the little summary, it says history none, but in the paragraph before the recommendation, it lists out some prior issues. So I was just wanting to be clear, was there no history related to, I guess I'm just not clear on why that's noted like that.
Yeah, so within this complaint, the respondent does not have any history under this specific license, but did have history under another license. Wendy, do you remember exactly which?
So the current complaint is against the individual. The prior issues are with the individual's firm.
And we just wanted to note it within the summary so that you were aware that this respondent was involved with previous discipline, just not under this license. And so that little history up top just goes with the license that the complaint was filed against.
Okay, thank you.
Mr. Chairman, I had a question on two items. Number 17 in the recommendation, it's not really stated what the penalty is for. Just that we're assessing a civil penalty. I assume it relates to peer review. And also the same thing on number 19. It doesn't really say what the basis for the penalty is that I can see.
Agreed. I think those are fair points. So with respect to 17, let's deal with that one. That is a firm peer review issue or fail to have a peer review. And so let's go ahead and wordsmith the recommendation that we might want to add there. And I would say for failure to comply with peer review requirements on the recommendation for item 17. And I just want to check with legal counsel to make sure
that's
they're
correct,
comfortable with
yes.
that.
Sorry. Ask a question there. I thought we were doing that for failure to have a firm permit.
17?
Yeah. So the individual had a permit, but not in the proper name,
That's correct. yes.
correct?
Okay, let me read over. I think I was reading the wrong one. Sorry.
Okay.
Yeah, Wendy's correct.
So just to clarify, I guess what we're doing is we're giving them credit for having re-enrolled in peer review. but basically affirming or recommending a penalty based on a lack of firm permit. Okay. So then the recommendation would be to authorize a formal hearing with the authority to settle via a consent order, assessing a $1,000 civil penalty for failure to have an active firm permit. Is council comfortable with that wording?
Yes.
Okay. And John, I'm sorry, could you go ahead and give me that other case number?
The second one was case 19. We indicate a penalty of $1,750, but don't indicate the basis for that.
Okay. Let me just take a look here. So this was the Iowa Board of Accountancy case. So as I'm.
Sorry, I was
Yeah.
speaking with Duke. Can you repeat your question? Sorry.
Yeah, so the question is that the recommendation for discipline in item 19 does not specify the rationale for the recommended discipline as whether it relates to failure to have a peer review or firm permit or both.
It should be, the civil penalty is based on $750 for failure to have a firm permit and $1,000 for failure to comply with peer review requirements.
Okay.
It should read the same as the one above 18 plus the referral to the Iowa board.
All right. And John, does that respond to your questions?
Great, thank you, Mr.
Okay.
Chairman.
Thank you. Any other comments or questions?
I have a question on item 14. Wendy, you gave us some clarifying information, and as I thought about that after you spoke, I don't know that I totally understand what you were saying. Is in item 14, is the individual a CPA that's just not licensed, or is it someone who was not previously a CPA?
So 14 is the entity. Sure.
So 14 is the entity that engaged the engagement, and they didn't have anybody on staff to complete a review engagement, and so that's why they went and contracted out for 19.
Okay.
And then the engagement was done under their purview, but then submitted under 14's letterhead, but signed off by, responded on 19 with their license, if that makes sense.
So 14 says it's the owner is not a licensed CPA?
That's correct.
So that's correct?
Yes, yes. It's not a firm, and the owner is not a CPA.
Thank you.
Mr. Chairman, your mic doesn't sound like it's on.
Thank you. So I would offer a motion to accept the recommended proposed discipline in cases for items 12 through 20, and then we'll deal with the representation separately, item 21. And the proposed discipline includes the recommendations additional for case 17, where we're adding in the recommendation a rationale for failure to have an active firm permit. And then for case 19, we're adding a recommendation to clarify that the recommended $1,750 civil penalty relates to $750 for a firm permit violation and $1,000 for failure to have a valid peer review in place.
Larry is making that motion.
Okay, we have a motion by Larry. Is there a second? Seconded by
Second.
Rob. Thank you. Any other comments or questions? Karen, will you please call the roll?
Kevin Monroe,
Aye.
David Crenshaw,
Aye.
Larry Elmore. Larry votes aye. Greg Gilbert,
Aye.
Rob Vance.
Aye.
Thank you. That motion passes. And then we have one last item. That was the representation on the case that's coming out of legal monitoring due to the disposition of the case and a default judgment being entered into, whereby the recommendation was to authorize a formal hearing with the authority to settle via consent order seeking voluntary surrender of the respondent's license. I would move that we accept the proposed recommendation on this representation. Is there a second?
Second.
We have a motion and a second. Is there any further question or discussion? If not, Karen, will you call the roll?
Kevin Monroe,
Aye.
David Crenshaw,
Aye.
Larry Elmore,
Larry votes aye.
Greg Gilbert,
Aye.
Rob Vance.
Aye.
Thank you. That motion passes, and that concludes the complaint adjudication. We also have the summary of the case and complaint report. This report actually excludes the cases that we have just acted on, but gives the board a sense of kind of the status of various cases, some of which are still in litigation monitoring. Those are generally more of the long-tenured cases in terms of age, and then some will likely be coming up to us in the October legal report. So that's just an information item. And that concludes the business of the Enforcement Committee, Mr. Chairman.
Thank you, Mr. Chairman. Record time. A great job. Next, we've got the Executive Committee. I'm the chairman of the Executive Committee, and we'll start with travel. Wendy has submitted a travel report for us, and I know I'm excited that she went to the NASMA meeting and the TSCPA meeting. I'll let Wendy kind of go through those with us and comment.
Thank you, Mr. Chairman. These are just highlights of travel that Duke and I have undergone that had expenses attributed to the board. As Mr. Chairman noted, I've got the 2024 NASBA Eastern Regional Meeting and TSCPA's annual convention on there in Kingsport, Tennessee, and then Duke's travel expenses to the last board meeting are included there as well. I did also travel for the AICPA Board of Examiners on 2 different occasions during this time period, but that was covered as a member of that particular committee by the AICPA.
And a couple things there, just we'll get into more of those tomorrow, what happened at the meetings, but thank you for your representation there, because there's some really big things happening in our profession right now. And I just applaud. I know it takes some time, but I thank this board for supporting Wendy to go to those meetings, because there's a lot of input right now, that things that are being suggested and solutions, and even with CPA Evolution and what she's doing on the other board, it just or the committee, it really is making a difference in the profession. I will say, since we have a couple of people here from the TSCPA, that when we went to Kingsport for our 93rd annual meeting, it was really exciting to see. Wendy was sitting in there, and we had a professor going over and doing state-specific CPE, and there was kind of a back and forth, like, you know, what happened here, what did you see here? And Wendy got to participate in that, and it was very eye-opening. I've had several people from the convention come up and talk how it wasn't as dull as it was in the past, because they had that interaction going on, and they were able to get real answers in real time of things that Wendy deals with every day. And so I'm grateful that you were there and you were sitting up front, and they passed her the mic and said, "Stand up," a couple times. So it was kind of neat to see. But I wish every board member could have been there for that, because it really highlighted the talent that we have here, not only with Wendy, but other members of the staff that help us for here at the board to do what we do. We're only better because they're here helping us, and I applaud that. Thank you. Next, we've got the financial statements, year-to-date 24. Everybody has gotten a copy of those. And I would say that it's looking up a little bit compared to where I thought it was. And I know that I understand that y'all been pretty busy in the last 30 days with some things. So Wendy, if you want to go through that and tell us what's going on there.
Thank you, Mr. Chairman. I'll just start out with an overview here, but the financials in front of you for the period ending May of 2024. Our fiscal year end is June, so we've got 1 month remaining here. But as of the end of May, we are at net revenues of $986,990 and expenditures coming in at $934,785. Leaving us on the positive side at $52,205, which, as you mentioned, is pretty good. So if we can see some decent revenue in June, we may be able to squeak out, some positive numbers there at the end. So we will see. We're very close. The revenues are favorable to budget and the prior year. Revenue is actually up 4.7% to the prior year and 3.3% to budget with 1 month remaining. Licensing revenue, though, alone is only up about 1.5%. So a lot of that is attributed to an increase in case and complaint revenue. We had, most of you remember, a fairly large case last year that contributed to over half of that dollar figure. So likely we'll not see that going forward. The state regulatory fee is favorable to budget. That is just coincides with how many individual licenses are issued or renewed to active status. So that is in line with our licensing revenue. Salaries, employee benefits, this is unfavorable to budget and the prior year, but as I've mentioned in prior meetings, this is due to a statewide enhanced salary restructure that occurred over a few stages in the past year and a half or so. And that was done after we created the budget for this particular fiscal year. Longevity compensation, also unfavorable to budget and the prior year for the same reasons. Travel is favorable to budget. We had less people attend NASBA's annual meeting this past year, and we still have the NASBA regional meetings that occurred in June still need to hit that line item as well. So we'll see that come up a little bit there. Communications and shipping is unfavorable to budget in the prior year. Postal charges, this includes charges for mailing of wall certificates, renewal notices, and certified mail when appropriate. Postage rates did increase 2 times during the past fiscal year, so that is contributing to some increases there that we had not planned on. Third-party professional and administrative services is favorable to budget. This includes shredding services, expenses incurred for formal hearings, and our NASBA Association dues, which is at $6,000 of that line item, and credit card processing attributes to a significant portion of that line item. Supplies and furniture, rentals and insurance, all favorable to budget. Employee training is favorable to budget in the prior year. Training for CPE and for registration at NASBA events is included there. Computer-related items is unfavorable to budget in the prior year. This typically will include technology-related expenses. Our Zendesk renewal is the bulk of this expense line item. That is our customer service ticketing platform that we use, and they kind of go back and forth on whether that falls in cost backs or whether it's direct billed to the board. And this particular year, it was direct billed to the board in this particular line item. And so I suspect we will see that going forward. State professional services is favorable to budget, covers telephone, IT support, rent allocation, state printing of our wall certificates, Secretary of State, judges if we need those. The increase over the prior year is attributed to an increase in rent and IT support. So IT costs just continue to go up. So we are noting that in that particular line item. We're doing decently on our year-end cost backs. We are unfavorable to budget, but in line with the prior year. The salary restructure does fall here when it comes to our legal services and our admin cost backs. So this is going to be affected in this particular line item. But I'm happy with where we are, that we are favorable to the prior year. So I think we're doing okay there. I did note in the summary there that about half of this represents our legal cost back at $109,000. Of that is our legal chargebacks. And so I think that concludes some specifics there. If anybody has any questions, happy to take those.
Do we have any questions on either report? Okay, seeing none, Executive Committee, anybody want to make a motion for approval of the travel and fiscal year 24 year-to-date financial statements?
So moved.
A second? Second. All those in favor say aye. Well, I got a call vote. I got Larry, pardon me. Karen?
Andy Bonner,
Aye.
Larry Elmore,
Larry votes aye.
Greg Gilbert,
Aye.
Kevin Monroe,
Aye.
All right, well, the committees have done a great job today, and we've gotten to this point. Next up is our public comment period, and I don't see anybody here present that wants to make a comment. Karen, do we have anybody that in the chat that's asked for a comment?
no, sir, we don't.
Okay. All righty, well, then we will see everybody tomorrow for the regular board meeting at 8:30. Appreciate everybody coming, and appreciate your time, specifically in the virtual world and also here present today. So with that, I'll say we're adjourned.
Thank you. After 9 years, we're finally efficient.